Namaste, I'm Diksha Yadav, your host for What This Means, a Swarajya podcast show where we discuss news behind the news. There are many issues right now that's being highlighted when it comes to judiciary and the judges with the Yashwant Verma's case. But what we want to discuss in today's podcast, dear listeners, is about the huge pendency of cases, which does not get much focus, or we all are actually tired of, speaking about it because we are so not hopeful that this thing will be taken seriously. So today, in today's episode, we want to understand what kind of cases are these and who is actually responsible for these backlogs and what can be done, what is the solution, and all about that. So today joining me are two lawyers, Nikhil Mehra, who is a Supreme Court lawyer, and Abhishek Dwivedi, who is a lawyer practicing before the Lucknow Bench of Allahabad High Court. Hi Abhishek and hi Nikhil, welcome to the podcast and thank you so much for joining us.
Good to be here.
So, starting with you, Nikhil, there are almost like over 5 crores or 5.2 crores of cases right now pending in courts. And the in 50% of the cases, government itself is a major litigant, right? And when it comes to central government, it's about over 6 lakh 98,000 pending cases. So, what kind of cases are these, and why we don't have a system in place yet to fast track these cases? Because the very entity responsible for strengthening the judiciary system is simultaneously, actually straining its resources.
See, Diksha, I break this down to two parts.
Hmm.
One is for the government to be a litigant, first there has to be a bad decision by someone in the executive,
Hmm.
right? And only when there's a decision that a particular citizen disagrees with, let's not say bad because it may be proved to be right,
Hmm.
but when a decision occurs that a citizen disagrees with, more often than not on a point of procedure and not just on a point of merit, because if it had to be on a point of merit, then it had to be in an area where an actual appeal against that decision was permitted. But even processually, there are problems, and problems in terms of the way jurisdiction is particularly exercised.
Hmm.
So, first is the inefficiency of the executive in the kinds of decisions that it takes, its inconsistency. And the second then is the persistence that the government has in continuing its litigation in the event that it fails. And there is a category here which is a particularly egregious category. This
Hmm.
is sort of the category where they keep chasing class 4, class 5 employees on their pension.
Hmm.
Uh, they keep chasing army officers on their pensions and their emoluments all the way to the Supreme Court. And when you look at these cases in the Supreme Court, there's just no dearth of the number of occasions on which the Supreme Court has essentially said, why do you keep doing this? Why is it that a secretary is always incentivized to
Hmm.
sign off on a file to say that a case will be filed? And over the last 4 5 years in particular,
Hmm.
in fact, I'd say even earlier when Justice Singhvi was still part of the bench. I mean,
Yeah.
and I could even go deeper back, but let's just go up to Justice Singhvi, which is about 10, 12, 15 years ago.
Hmm.
There are at least n number of occasions where he has summoned the secretary of a department to say, why did you file this appeal, right?
Okay. Hmm.
Now there is the other element to this, which is really nobody's fault,
Hmm.
is the Indian state is actually quite a large apparatus, and it intervenes in a lot of what would otherwise be private functions. Aside from this, it has certain very peculiar functions.
Hmm.
One of those peculiarities is, say, determining your caste, and your eligibility on that score tends to determine your life prospects in terms of being able to go to university and so on and so forth, right?
Hmm.
So there are a lot of decisions that the state takes which are immediately challengeable, and you'll see that there's a flood of litigation in relation to things of this sort. There is another category which is in relation to the police and
Hmm.
how often the police take they guilty of inaction or overaction,
Hmm.
as the case may be, right? So there are various categories of cases that come from the size of the government, one, two, the quality of decision making at the executive level, and three, then the persistence of the government to keep on continuing with its litigation for fear that if they were to not litigate,
Hmm.
then that particular officer would be called out for having caused loss to the exchequer. And four is that the general nature of the Indian state is so large,
Hmm.
it covers so many aspects of your existence that it is bound to be a major litigant.
So there is no way out for this where government is a major litigant, because uh, you know.
There is no way out because nobody wants a way out. Look,
Hmm.
there has to be some kind of decision making power. This is the problem that happens is this. Let's say there's a particular, let's say we were to set a criteria that says, if the case is going to cause this has often come up.
Hmm.
I'm not giving you a fictitious example, but if the case involves less than say 20 lakhs of liabilities or 50 lakhs of liabilities, no appeal to be filed, or only one appeal to be filed, nothing more than that, right?
Okay.
The problem that they face is that you will, in the actual case, have an army officer or a class 4 employee whose pension claim may be in the thousands, maybe 30,000, 40,000, maybe in the low lakhs,
Yeah.
4, 5, 6 lakhs. But they will say that if we lose this on principle, then that becomes a much larger claim going forward, because it will affect so many more people,
Hmm.
right?
Hmm.
I am talking about cases where people are deprived their due emoluments,
Yeah.
post-retirement benefits, for example,
Yeah.
for decades after retirement. In effect, their own life, which was supposed to be their post-retirement life, which was supposed to be made comfortable by these payments,
Yes.
is never given that comfort, and it is only their children who may see that money,
Hmm.
right? All of these things, to my mind, tend to have a knock-on effect on why corruption also occurs. So
Hmm.
there's a certain inefficiency in the system that is inherent to the system, and any participant within the system has a sense of foreboding that
Hmm.
anything could happen to them at any point in time, and there is no dearth of cases where, to teach a person a lesson a day before, 10 days before, 15 days before their
Yeah.
superannuation is to occur, some
Hmm.
kind of disciplinary case will be placed upon them, and their pension will be stopped. There's no dearth of such cases.
Hmm. Hmm.
So, you want to be able to set limits. On commercial side, you can set these limits, no problem.
Right.
We get another problem on the commercial side.
Hmm.
Let's say you are government and you lose a commercial arbitration.
Yeah.
You are not stopping. There is no department that turns around and says, we've lost fair and square, let's leave it be.
Hmm.
You will go and appeal in section 34. There are certain arbitrations in which now the courts of section 34 has been changed. Justice Chandrachud at one point in time has passed a judgment that a particular arbitrator has acted in a particular way,
Hmm.
where we will travel beyond the parliamentary remit of section 34 and interfere in an arbitral award in favor of the government against the Ambanis, just because we feel that this is necessary in interest of justice. This interests of justice
Hmm.
jurisprudence
Yeah.
inspires everybody to litigate. Trust me, because it's basically a Hail Mary.
Yeah.
So the government of
Hmm.
India, instead of taking its liabilities
Hmm.
head on and then saying we'll pay them out, keeps on litigating against them. Now, let's say they even go in
Yeah.
34. They lose in 34. They go all the way to the Supreme Court. They lose to the Supreme Court. Now starts execution. They will resist you in execution.
Right.
So a new set of proceedings you are initiating in execution, and there'll be multiple set of applications you're filing within that
Hmm.
proceeding, just to be able to get what you have already won in a prior round of litigation. And the government,
Yes.
for all its claims of efficiencies, eventually the Babu who has to take the final
Yeah.
decision
Yeah.
does not even adhere to that policy, and keeps filing these cases.
And this is when this pendency of cases is when a lot of people are not filing cases who feel they need to go to the courts for some reason or the other, whether it's businesses or individual or families, because just because of they know they have no clue how much time and delay it will take, and how much money it will cost them, and leave alone the mental uh, you know pressure and everything that they go through. Even businesses and
Disha,
MSMEs.
one thing I'd like to caution on
Hmm.
this, by
Hmm.
the way. I remember reading a news report at the start of the
Yeah.
year that last year was the first year in which disposal was greater than filing.
Okay.
I don't remember whether that was
Hmm.
for the Supreme Court per se or across the litigation system, but I remember reading that
Hmm.
report. I believe it was across the litigation system, but that may be, as you're implying, there may be a lot more divergence towards arbitration and
Hmm.
mediation,
Hmm.
or just not filing. You're
Yeah.
right. People are just like, it's not worth it. You see, you can't have an efficient legal system where you cannot call an efficient legal system efficient when your per capita income is at about 2,700 or $3,000 a
Yeah.
month,
Yeah.
right? But to a person, to an individual, average layman, filing a case for a 5 lakh claim, because 5
Yeah.
lakh then is not a small amount to
Yes.
them, or 8 lakh is not a small amount to them, filing that claim is utterly
Hmm.
pointless.
Hmm. Yeah, it is. It takes their time and energy. I've been seeing this MSMEs and small businesses complaining when they are, pulled into such kind of things. They're like, instead of filing the case, we pay the, money or whatever, because it will take our time, it will take our energy. We are here to do our work. So yeah, that's there. So Abhishek, most of these pending cases, about 85% of these pending cases are of, district courts alone or the lower courts. So what are the challenges that district court faces, and how much, what part even the resources and infra plays here? Like, do they have the bandwidth to even, take up this backlog of cases?
Hi Diksha. Before I begin, I must put out the
Mhm.
disclaimer that no disrespect is meant to any member of the bar, the honorable courts, the honorable lordships,
if
or the
if lawyer has
constitution
to say this.
by any of my views, which have been made harmlessly and without any motive.
Right.
May the majesty of justice remain unblemished forever. Having all my statements are fictional henceforth, and nothing has any resemblance with anything dead or living. Having said that, firstly, couple of things
Mm.
before I move on to your question. Nikhil is right. Last year, the disposal rate was
Mhm.
much better than the filing rate, and in fact, the trend has continued
Mm.
this year. In fact, only in last month, we have been able to dispose 8 lakh cases more than what were filed. Total 22 lakh cases were filed last month, and 31 lakh have been
Mhm.
disposed. So that's a good trend that has started. Coming to the point of resources, we are thoroughly unequipped. We are thoroughly unequipped to deal with the amount of cases and the population explosion that has led to these
Mhm.
cases. Our infrastructure is in shambles. Our judges per million ratio is one of the
Mm.
worst. I think we have around 20 or 23, 24 judges per million compared to US or European countries where it's around 150 per million. The law commission reports have requested that at least make it 50 per
Mhm.
million so that we are able to handle it, but nothing has moved in that regard. Hiring in lower judiciary is a very cumbersome process. More than often, the vacancies are publicized, then exams take place, and it takes almost 2 to 3 years for the results to come out, only for them to be cancelled or quashed by the courts because of violation of some procedural process or some or cheating related issues that happened in UP recently, where it was found out that the complete answer sheets were changed for almost all the
Mhm.
toppers. They were allowed to put their answer sheets later. So these are the difficulties that have happened in recruitment. But apart from that, we are thoroughly unequipped in resources. I'll give you an example of
Yeah.
Lucknow. There are two commercial courts
Mhm.
functioning. Both of them have judges who have worked in family courts prior to this. Both of them are good judges. I don't deny that they are not good judges. But for them to having practiced solely in family law and other kind of law for all their life and then suddenly made presiding officers of a commercial court, they found it very difficult for at least first 5 6 months to understand what exactly is the commercial practice
Mhm.
side. They were given certain trainings and all, but all of them were academic. The purpose of the Commercial Courts Act, and this is where I'll credit the government. The purpose of the act was to have specialized courts with specialized judges with specialized and summary procedures to fast track commercial transactions and make India a better country in terms of ease of doing business or enforceability of
Mhm.
contracts. But what has ended up happening that the regular judges are being appointed who are trying their best to solve these issues but are not specially trained judges. They have not practiced in this field for, let's say, at least even for 2 years. They haven't. They have not seen, and the act has changed. Acts matlab the arbitration act keeps
Mhm.
changing very quickly, so unless you are familiar or unless you have practiced in the field, you'll find it very difficult to run a commercial court as presiding officers. Same goes with high court. The commercial division that it was envisaged under the act that there will be separate commercial divisions. I don't know about Delhi, Nikhil will be better placed, but in
Mhm.
UP what has happened that the regular benches of high court have been given additional charge of commercial division. So there are 1,000 matters which are listed before the court. Two or three of them will be commercial matters, and the purpose of Commercial Courts Act to fast track the commercial matters so that the money is not
Mhm.
stuck and it keeps revolving, or the transactions are enforced, the contract sanctity is upheld. These principles have absolutely no ground to stand when it comes to High Court. It's the same bench which is dealing with miscellaneous writs, and it has absolutely no time to actually spend in these complex commercial matters. For instance, hearing an appeal against a Section 34 order upholding or setting aside an arbitral award. Now, just Nikhil explained
Hmm.
it very well. I initiated an arbitration for 20 lakh rupees.
Yeah.
Let's assume the arbitration took 1 year. I won the 20 lakh rupees plus interest at
Hmm.
12%. The government or the other side, let's assume it's a private party. The private party challenged it before a commercial court. The commercial court judge will summon the record from arbitrator. The entire process takes another 1.5 years. Then he goes to 37, challenging the same. In 37, the entire process will again take at least 2 to 3 years or 3 to 4 years. Then he will go to Supreme Court. Specifically, if it's a government, then they will 100% go to Supreme Court.
Right.
They will lose in Supreme
Hmm.
Court. Then they will file a review. They will lose in review. They might file a curative. What happened? He mentioned that I will not give money to Ambani's. That's what happened. The government filed a
Hmm.
curative. They will file a curative, assuming he loses it. Then I file my execution that the now award has become final. I am entitled to this money. Every court has said that I am entitled. Please pay me this money. Then he will challenge it again.
Okay.
No, execution process mein there is some mistake, something is happening, and we are facing it here. I have an award of 50 crores from
Hmm.
2017, and till date, not a single rupee has been paid because the government is filing applications after applications, and when if you see those applications, that's a gross abuse of process. Same government officials is taking two different roles and filing contrary affidavits before same court on behalf of two correspondents. It's a gross abuse of process. In any other jurisdiction, the officer would be hauled, he would be held in contempt, he would be jailed. In fact, he would be sent to jail by the court. If these affidavits go before Supreme Court and goes before someone like Justice
Hmm.
Oak, or in fact Justice Pardiwala, he will be sent to jail directly from court. The kind of affidavits that are being filed by government officers, and he's a well-read officer. It's not like he's some babu.
Hmm.
He's a well-read officer, and he's filing such affidavits. So it has become a common practice that the government, or for government bhi aap chhod dijiye, it's like every litigant. We are a very litigious society. Nobody wants to enforce
Hmm.
contracts. If today government is doing this to Ambani's, the Ambani's are doing it to smaller
Yeah.
players. I know for a fact that today half the MSME payments are stuck, which who deal with these companies in Bangalore and Bombay. Kanpur is suffering. Kanpur, we see a lot of MSME disputes in
Hmm.
Kanpur. Half of the payments are not made by people, are by textile factories in Gujarat, or the procurement factories in by matlab, the big factories. I'll not name the corporates. The big people, they are not making the payments, and it's not like they will not make the payments. They then, when we file the case, then they wake up and they're like, acha, acha, you take the money, will not pay any interest. If you want your money, you do it right now, otherwise we'll go to Supreme Court.
Hmm.
Now these are MSMEs, they will accept it, but the delay is on part of everyone. We are a very litigious society that way. So resources are thoroughly, coming back to point. Sorry, I went a little astray. Coming to resources, we are thoroughly
Hmm.
unequipped. For example, the Allahabad High Court requires 160 judges. We, as of now, we have 77 judges. Three have been sent yesterday. One of them will not take judicial
Hmm.
function. One another judge is not well, so he has not been attending courts. So at the end, we will have 78 judges again against a vacancy of 160
Right.
judges. For last 3 years, there have not been a single appointment in Lucknow Bench. For last 3 years, there have not been any senior designations. We have one of the best infrastructure when it comes to Lucknow, but our district courts are in a terrible shape. And I don't see
Hmm.
how the situation will be rectified unless we appoint crazy number of judges, ad hoc judges appoint kariye, or have at least 5 6 benches who are just hearing cases without any fresh matters, just hearing old cases, disposing the cases from the
Hmm.
oldest. But this will require an effort from the government, the judiciary, and the bar.
Right, right. So two things. Let me come to Nikhil, and I'll get back to you on the this tribunal courts part. So Nikhil, this vacancy of judges, it's over 5,000 in lower courts only. So we see that like in news, we keep on seeing that sometimes it's the state governments that put the stay on recruitment of these judges. Sometimes it's the higher courts that put a stay on this. So what's the problem here? And this is how are we failing in recruitment? I mean, of course it's happening in other government exams as well, but this is something, why don't we have a proper system yet of filling this vacancy? And how much? And also sometimes we see that people are saying that there's a skill gap, we don't have good judges, and that's why. So how much do you give that reason? I mean.
So two things to this, just to first frame the scale of the problem,
Hmm.
right? We say 5,000 short on lower court judges as per the estimates we have had, and these estimates have not been revised for a long time.
Yeah.
In my opinion, you're probably 50,000 short. I'm not joking with you. If you were to multiply the lower court judges by a factor of 10,
Hmm.
then you might start arriving at a position where you can finish off cases in a year, year and a half, even suits. Okay,
Hmm.
in particularly in these lower courts. There are other procedures to be followed. Now, why are these exams the way they are? They are like every other exam in the country.
Yeah.
Why do we have a skill gap? We have the same human capital problem in every other aspect of the country. It happens. I mean, what can you do? You cannot make this a more attractive system. When I say, for example, multiply the number of judges by 10, then you also need the facility, right?
Yeah.
You need the courtrooms, you need supplementary staff, you need all of that to be put into place, right?
Hmm.
VCs have really helped. Trust me, this video conferencing system has really helped so that you can't be skipping dates
Yeah.
anymore. And that is why pendency is coming down, because disposal is going up through VCs.
Hmm.
And judges are then able to just take a hearing sitting in their chambers or even at their homes, home offices at times.
Yeah.
This is how, for example, a lot of debt recovery tribunal cases have been going on, which is perfectly fine. I don't require all the tamjham of a court. What I
Hmm.
require is for you to be able to put your mind to the submissions that I'm making, right?
Yes.
So those things help. But overall, we still have that same skill gap problem. We still have the same problem in terms of judicial appointments. Look, why is there no judicial reform? Why is there no police reform? It doesn't exist because politicians are extremely vested with these two sources,
Hmm.
right? Prakash Singh comes up with a report in 2006. Supreme Court accepts that report in a PIL and says there must be police reform of the sort that is described in the report. Issues notice to states, please do it. We are 20 years later, nobody's come close to doing it.
Right.
Why? Because for a politician, control of the thana
Hmm.
and indirectly, therefore, control of the kacheri,
Yeah.
this is your starting point of your politics. If you do not have this kind of control, then at the lowest level of politics, you are nobody, you're nothing. This is the first point of definition of you as a genuine political player, as a person who has influence within the government machinery.
Hmm.
Street side gundagardi, many people can do, but can you convert that into power within the police station and within the judiciary? This is the honest and hard truth of the matter, right? So if you were to keep adding in newer and newer blood,
Hmm.
politicians will lose their power, or more people will gain power, and this is all eventually a feudal turf control system,
Yeah.
right? And that is why also judges don't get appointed to the high. I mean, for example, today Abhishek mentions 160 judges should is the capacity of Allahabad High Court. That is by an older estimation.
Hmm.
In my opinion, that number should be much higher now. We are nowhere near that kind of elevation. I'm lucky to be practicing in Delhi, because of the Delhi High Court is a very vibrant system.
Hmm.
It regularly elevates lawyers from within the bar onto the bench, regularly takes lower court judges and puts them onto the bench. We also have a shortage, but we never have that great a shortage.
Hmm.
Forget us. In my 20 odd years as a litigator, I can't think of more than 1 or 2 years when the Supreme Court has not been below its sanctioned strength.
Right.
Right? So this is a perpetuated problem. Now the answer the government said is, you as court, as the collegium, cannot keep filling every single post in every high court all the time while doing your judicial work as well.
Okay.
80 judges, where is an Allahabad High Court judge and then Supreme Court judges to find 80 judges, 80 competent people to fill a position as privileged as a judge of the Allahabad High Court? It's not as easy. It's not that there's an application procedure. You're literally looking at people who have a track record, whether in the lower judiciary or within the bar, and then trying to elevate. Now, as he says, and this is extremely dispiriting, not a single appointment in Lucknow for 3 years, not a single, nobody appointed a senior advocate for 3 years. You brought people's careers to a point of stasis.
Hmm.
This is completely unfair, and it then obviously it goes upstream. Obviously, it goes into the judiciary, because if you are not elevating them to senior advocacy, you are not elevating them to the bench eventually. These problems are really, to me, these are feudal problems.
Hmm.
They are problems of turf control. Yes, you can break them down into saying, look, oh, an exam needs to be conducted better, so on and so forth. First and foremost, the persons who are gaining control of judicial and police
Hmm.
have to have the capacity to relinquish that control. Otherwise, this doesn't change.
But eventually, don't you think this would, I mean, not a bigger unrest of, I don't know if it's the right word to use, but we see the with other government's exams also, like people are frustrated and they also blame the government and the court. Then if it's happening in the judiciary system also. And then of course now with the all social media and everything, everybody is aware. Before it wasn't like any other field, student or people would be aware what kind of judgments courts are giving, but now any absurd judgment or anything unfair, it's highlighted and everybody is kind of enraged in that sense. So eventually it will harm the political class and also the judiciary, don't you think?
No, I mean, look, it's a very brave step the judiciary took, which is to have live streaming, live
Hmm.
video streaming of their hearings. And frankly, you can do live videos. Like, you can be sitting wherever you are. I can send you the links. You can look at
Yeah.
every single judge, even on the trial courts of Delhi, on a given day.
Okay.
If you
Hmm.
go to YouTube, you will find
Yes, all the.
older, right?
Yeah, yeah.
It's a very brave step. This is the kind of transparency no one else has taken. Obviously, it's going to look worse from time to time. But please read orders more and forget about the comments that judges make. The comments are made to us sometimes just to test the scope of our principle, the scope of our argument. And in doing that kind of thing, a judge may have to take an absurdist position.
Hmm.
Okay, this is the reality of it. Now, sure, it gets exposed. Let's say it gets exposed. But my theory on India, Diksha,
Hmm.
is that we just do well enough for more than enough people so that nothing ever really spirals out of control in terms of, a major
Perfect
war on the
balance.
ground, a major. Yeah, it's just it's a perfect equilibrium of inefficiency, in
Hmm.
that sense. But I say this, right, and then yesterday I was having this exact same conversation with my mother,
Hmm.
and if you ask her, she'll tell you that the amount of change she has seen
Yeah,
in her life, and she's born in 1950, is just stunning to her. It's remarkable how much we move forward, right? So it may be a slow pace of moving forward, and it is frustrating that we are now visibly losing certain decades where we could be doing so much more,
yeah,
because we've got past that original hump, that original problem we've got past.
yeah,
Now, I brought up the issue of video hearings, right?
yeah,
I brought it up because when you need something done, which seems complex, you can get it done,
yeah, yeah.
right? And we did really well with that.
Hmm.
Dhananjay Chandrachud deserves immense amount of credit for that as Chief Justice. He pushed it. He said absolutely no options on this. Every single court will have this.
Yes, yes.
Now there are more Supreme Court judges who are more hesitant about the efficacy of a video hearing, but nobody who says that infrastructurally it is not a necessity.
Hmm.
Infrastructurally, it is an absolute necessity, and it will help. It cannot but help.
Yeah,
There are other
yeah.
things that we are doing. For example, in trial courts,
Hmm.
it's nearly impossible now for you to conduct a cross examination of a witness under the eyes of the very judge who will decide the case, because their pendency is so high,
Hmm.
right?
Hmm. Hmm.
So we tend to pay for the appointment of local commissioners and court commissioners for the recordal of evidence. And these are very efficient systems, very
Hmm.
efficient. I can take a very complex case with, say, 15 20, well, I wouldn't say very complex, but reasonably, like, this is a typical civil case between two private parties. You may have 5 to 7 to 10 witnesses on one side, something similar on the other side,
Hmm.
of which 1 to 2 witnesses will be core witnesses. They have a lot of the story to tell. Everybody else is proving small bits of the case. You can finish all of this in 6 to 8 months very easily,
Right.
right? That, and I promise you, if you were to sit in court and try and do this, you're going to take 5 to 8 years. So it's not as if the system is asleep and it's
Hmm.
just a behemoth that's not moving. It is acting. There are a lot of things that are actually very obvious that we can do. We've spoken
Hmm.
about this before. The problem is that when you make a law in India, right, it is not as if we create legal laboratories across the 30 odd states and union
Yeah,
territories. We do it. If we do it, it's an elephant's foot. It happens in Delhi and it applies to everybody, right?
yeah.
But let's say you had a more a richer state like Delhi,
Hmm.
more progressive systems, more education levels, were to introduce a concept of discovery. Discovery is what? Both parties, prior to the initiation of litigation, are mandatory to exchange all their by relevant, I mean in the loosest possible term, evidence relating to the case. You cannot withhold anything. If you withhold anything and it is later found that you have withheld anything, you will face severe consequences for that, right? So that you exchange your evidence with each other
Hmm.
and you are able to evaluate what your chances are. And perhaps when you don't litigate, you settle, you do 100 other things,
Yeah,
right?
yeah.
Because trust me, this system works in the US, works very well, this discovery system.
Hmm.
Because even there, in most counties in the US, if you enter into litigation on the civil side,
Hmm.
it takes years. It's not as if they have some magic bullet for this. Judicial systems are like this, they will take long. Inevitably they will take long. High profile cases, celebrity cases. I mean, even take the Johnny Depp Amber Heard case. Eventually, that complaint was pending for years before it was finally heard
Yeah.
before the world's eyes, as
Yes.
it were.
Yes.
So you have to be able to accommodate all of this.
Hmm.
But just to summarize, first go get the numbers. But for numbers, you need to start identifying talent. To identify talent, you need to make your service conditions better.
Hmm.
You need to have more courts. You need to have better courts, so on and so forth.
Hmm.
Then go and identify how you are going to create a system that can constantly keep replenishing. This is where NJAC becomes a point of debate,
Hmm.
point of argument, right? And then identify that how do you keep this supply line constantly moving forward, right?
Hmm.
And you diversify from the same families having the same sort of impact within the profession.
Hmm.
Then I think you can start making a change. Otherwise, like I said, it's never bad enough and it's never good enough. This is the nature of India.
Yeah, actually, so true. But yeah, the new sad or black pill is that in every aspect, when we talk about economy and justice and everything, it's like we are growing when we compare to the past decade or so. But then it's very slow, and we feel that it is the high time that we need to pace up. So that's also becoming a black pill that we are better now, but it's slow.
Yes, I will disagree with Nikhil a
Hmm.
bit. While I credit Justice Chandrachud and the Supreme Court for taking technology through video conferencing, I think that it has completely been lost, at least in states outside
Hmm.
Delhi. In UP, courts are very, very reluctant to go use
Hmm.
VC. They request, if a lawyer is appearing from Delhi, they request that you please come and appear, or they would deliberate. The VC will not suddenly will stop working, and the local council will have to
Hmm.
argue. When you go to Northeast, I had a matter in Tripura, and I kept requesting the local councils to request for VC, but they were told that the local bar association had barred them from requesting for any VC hearing. And if I wanted to appear, I will have to travel all the way there. So I don't think the VCs are working, except Delhi and couple of courts with or couple of judges across the high courts. The VC is not working as far as my experience is.
Okay. Hmm.
Secondly, VC has its own difficulty also, which I have faced repeatedly, at least in UP, when it comes to RERA. What happens? RERA has these hearings on
Hmm.
VC, and while you are making submissions, the judge will suddenly decide that, ठीक है, order reserve. And I'm like, my lords, I have two more arguments. तब तक I am being thrown out of the meeting.
What?
I cannot even say anything further. They just disconnect. They just move on. Or they just mute you. नहीं नहीं हो गया आपका बस mute. I want to make few arguments. I want to reply to something,
Hmm.
but nothing. I will not be allowed. If I'm in an open court, I can say, no, my lords, I'm on the dais, you will have to hear me. Or please make it not before. Send it to someone else if you don't want to hear. But I have no such opportunity there. Now, for me to then go from my office to RERA, by the time I reach, the court would have gotten up. Court बैठती भी नहीं है. They do it in their chamber, as Nikhil mentioned. So you can't even meet them directly. कि boss, I had some other arguments that had to be taken note of. So these are the difficulties at least we are facing in this side. As Nikhil mentioned, ki, matlab, in Delhi also doesn't have that much shortage of judges and it has a more vibrant
Hmm.
culture. That is the tyranny of distance that we feel. It's closer to Supreme Court, so Supreme Court, it's out of sight, out of mind. We are out of sight, out of mind. I don't know whether we are only or all the other states. Because we felt this during COVID also, and we feel it now also that Supreme Court doesn't care about us that much.
Right.
The judgment, for instance, I'll give you an example. The suo moto judgment that there was a very controversial judgment given by an Allahabad High Court
Hmm.
judge regarding the attempt to rape and preparation for rape. Now, that judgment caused a lot of uproar. You must
Yes.
have seen on
Yes.
Twitter. That judgment may be right or wrong, but it was not an unreasoned judgment. The interpretation may be correct or incorrect, but it was not a judgment where some extra jurisdictional or a patently incorrect invocation of jurisdiction was there, that Supreme Court will have to take a suo moto and pass certain strict remarks and write a judgment which says that this interpretation is not found in canons of law or something that is absurd.
Hmm.
And we believe that such remarks are being passed repeatedly against at least UP Allahabad High Court repeatedly, that your listing system is not good. Why are you not hearing cases?
Hmm.
You are not giving us judges to begin with.
Hmm.
We have 17 judges here. One court is hearing 150 fresh matters every day. How do we hear the matters that you direct us to hear? And then you criticize us at every opportunity. We see Justice Gavai, Justice Adiwala, Justice Oak, everyone is criticizing UP Allahabad High Court that boss, you're not disposing of the matters. How do we dispose? We don't have the resources.
Right. Right.
So
E-
it's a little different from what Nikhil said in
hmm.
terms of technology and
Even
changes.
the
The changes are much less in
hmm.
places apart from metros.
It was only in COVID that we started seeing. I think Gujarat High Court was first. That on YouTube, these video uh, conferencing was taking, like, the cases were being heard and everything. It started there. But yeah, one thing is this, that it saves a lot of, especially if you look at the people. The smaller parties, if they have to, it saves them from a lot of traveling from one state to other and all of that baggage. So one thing is this, that you're saying that it's not the same case with, say, in UP when it comes to video conferencing and cases like that.
See,
And second is, why
one
have
of
we?
one of the reasons
Yeah.
video conferencing failed in UP was I will be blunt. It was because of live law bar and bench. These guys
Okay.
started taking clips, taking statements, observations, as Nikhil mentioned, that you don't have to see the observations, you have to see the order. The sensationalization that was done, the clips that
Hmm.
went viral on Instagram and on Twitter, everywhere, taking just one part of the clip. If the judge is saying, it was just like Ashwathama, because हमने सुना था ना, it was the way it was misrepresented, the entire thing. If I'm saying one sentence, it was cut. It was sensationalized, the every single statement. If today justice, there was a time when Justice Chandrachud, if even if you would have sneezed, I'm certain every single reporter at bar and bench and live law would have tweeted it with a heart emoji. Then the
Hmm.
Ram Janmabhoomi judgment came and completely changed for him. But till then, this would have happened. And these guys sensationalized everything. So that one of the reasons that the judges are today scared to even opt for VC hearings is because they lose their freedom to be a little strict or harsh or be the devil's advocate. The moment they say something which might be to provoke an answer, as Nikhil mentioned, it will be quoted out of context. So one of the reasons that the technology has not done very well across, see, Delhi has more polished judges, there's no doubt about it, but across the country it
Hmm.
has not worked is because of the sensationalization that these legal portals did, and I squarely blame them for this. That you sensationalized
Right.
every single statement that was made, and usual
Hmm.
suspects on both sides were very happy to get a chance to get back on judiciary, get back on judges. So it was very convenient for them.
Right. But another thing is that when it comes to, how judges or the how the cases are prioritized, at which cases get heard on priority basis, and sometimes more severe cases also are not taken on priority basis and things like that. So why have we not incorporated technology now? Now it's been quite some time when AI and everything has taken over every aspects and almost in every profession. So why not have a good system where at least all the pendency of cases can be prioritized and taken up and things like that? I'm sure other countries might be doing it.
Okay, so there are categories of cases that are prioritized by their nature, right?
Hmm.
So these are criminal appeals, bail cases, etc., prioritized definitively. A lot of this rubbish that goes on
Hmm.
online, that oh my god, ex lawyer got a hearing,
Hmm.
right?
Hmm.
Just don't fall for this rubbish. If you have a genuine urgency, I mean, Abhishek will tell you about Allahabad, but I'll tell you about Delhi,
Hmm.
both High Court and Supreme Court. If you have a genuine emergency, you come to my office say at 5 p.m. I can have a petition ready overnight. I can have it listed and I can have it mentioned in the morning at
Hmm.
10, and I can have it heard by 2 o'clock.
Okay.
Okay, but that has to be a genuine urgency,
Hmm.
right? People get upset that the court is open at night for a terrorist who has a death penalty pending against them. Fair enough.
Hmm.
That's your view.
Hmm.
You think it's an open and shut case. With the Supreme Court, a person is about to die, and the state is about to put a person to death
Hmm.
by judicial fiat. And for whatever reason, their lawyers have come up with an argument. What is the court to do?
Hmm.
The court actually sits up at night because what it does not want to do is to defer that particular hanging, right? That is scheduled as a 5 a.m., 6 a.m., whatever the hell it may be.
Hmm.
So it sits up at night and it listens to your argument, disposes, and moves on with things. These are not remarkable or out of the ordinary circumstances. There are a number of cases in which priority is not a problem,
Okay.
right? In Delhi, in particular, I do not feel it is a problem. I have observed, this is from my practice, Bombay is becoming a bit of an issue.
Hmm.
Bombay is so badly backlogged in the High Court that getting a listing, forget about getting an urgent listing, is a near impossibility unless you're saying I'm about to get demolished in 2 hours,
So,
right?
mhm,
It's almost as bad as that. But I think on the whole, every court has a good system for genuine urgency.
right.
Now,
But
and they will, and that is why the practice has sort of evolved into go get your interim order, and then you sort of live and die by that. The case lives and dies by that interim order.
yeah, but what about the pendency of cases which would be like, pending for decades now? So, kind of to actually, I'm talking about using that technology for actually making backlog, getting rid of the backlog easier, you know?
But Diksha, how do you use technology? And I want to understand this. I mean, look, at the end of the day, there has to be a judge who has to hear, has to make a determination, and has to provide a judgment, right?
Hmm.
It can't be like, unless you're suggesting AI be used, but we're nowhere near that. Let's be crystal clear. So if a judge has to hear, there is only so many hours in a day. What is the judge supposed to do?
Right, right.
Now, you could again ostensibly have night courts. There are night courts, by the way. Criminal law in particular, there are night courts. That's it.
I mean, just to.
You could have
See,
night courts. You could easily extend the retirement age. But if you extend the retirement age, please understand the costs on government go up as well.
Hmm, hmm, hmm.
Right? Today, High Court judges retire at 62, Supreme Court judges retire at 65. In our lived experience today, 62 and 65, people are firmly in their middle age.
Yeah.
They're extremely active, extremely smart, extremely sharp, probably at their best at that age, right?
Hmm, hmm,
And so you could easily extend this by 5 years, right? And fine, you do that, but then please understand that the size of your judicial
hmm,
cadre
hmm.
rises, the amount of courts you need rises, the number of resources you require rises, and if you can make that investment, from the start I said multiply the number of trial judges by 10. I think the capacities that you're estimating for these courts are lower than they should be. They should be higher capacity. Start identifying more people. If you can do all of this, everything will dissipate. There are great theories. Even the theory of discovery, for example, that I was saying, might ease things somewhat. Okay, it might ease things somewhat, but it's not going to make a huge dent. The
Hmm.
only thing that changes things is the number of judges per people. That's the only thing that changes
That's
things.
true, but just looking at the numbers, like over 5.2 crores of cases that are pending. So, in that sense, if we use like prioritize, which are very old cases, or most of the cases would not require that much attention, right? Because I mean, won't be all these crores of cases won't be that serious one.
No, I accept that. And in fact, let me go a step further.
Hmm.
This was something that was done in Singapore at one point in time. They had a registrar who was told, "We need to get current. You have 5 years." He basically took every case and set dates.
Hmm.
Right? You will be heard on so and so date.
Hmm.
And if you didn't turn up on that date, tough luck. Your case is gone.
Hmm.
And so the way they saw it was a lot of injustice occurred over those 5 years.
Okay.
A lot of cases that shouldn't have suffered did suffer over those 5 years. But systemically, you arrived at a point of justice.
Hmm. Hmm.
Can you take that kind of harsh step in India? That's for the governments and the courts to decide between themselves.
Right.
firstly, Nikhil saying that AI has no applicability to justice delivery system as of now would affect a lot of law students, and they will have to change their profile on LinkedIn at least. But having said that, now see, I believe that technology has to be used in streamlining the procedure that leads to the cases being heard.
Hmm.
What Nikhil suggested about Singapore is something you remember we discussed yesterday, that dates could be fixed by AI,
Hmm.
or not AI, by technology, that आज से आपका है ठीक है, your petition is being admitted, this is the order has been passed, this is the case management, this date pleadings will be exchanged, this date. And I think it happens in Delhi, it doesn't happen here, but I remember appearing in a matter where there were dates fixed that on this date the pleadings will be exchanged, this will be listed before registrar for this will be listed on this date for that purposes, and then we used to get notification that this has to be done. So similarly, that has to be done across the country. And secondly, the filing system
Hmm.
has to be made much more simpler and uniform across the country. Right now, if you go to website of Madras High Court, and someone who practices in Tamil Nadu will not be able to operate the website of Allahabad High Court. Somebody who I work in Lucknow, and I cannot understand head and tail of cause list in cause list, matlab the case list of Delhi. So somebody will have to make these things uniform so that the litigants across country can be aware. one of the biggest difficulties that litigants face today is that they are solely dependent on their lawyers,
Hmm.
who are mostly, matlab, with all due difference, who are either very busy or a little bit inconsiderate in explaining what the status of their case is. हाँ लगा था, हम बताते हैं. हाँ डेट लगी थी, नहीं पहुंचा. आप स्टेटस नहीं बता पा रहे हैं कि आपके मैटर में हुआ क्या है. हाँ देखते हैं, आज जज साहब छुट्टी पे थे. यू हैव टू एक्सप्लेन देम, अपडेट देम कंटिन्यूअसली, सो इट वुड बी अ मच बेटर.
Hmm.
ऑल्सो लिटिगेंट्स आर नॉट अवेयर कि कब उनका केस लगा है. So that would be much better if we use the technology to make streamline the system of filing,
Hmm.
listing, every document being scanned, every litigant having a copy, every lawyer having a copy. जिसने वकालतनामा फाइल किया, he should have access to the files online. So tomorrow the issue may not arise, or the judge should also have it on his computer, that it may not happen that the matter reaches, because a lot of time what happens that the matter reaches in the court and the court says the file has not come yet, और द रजिस्ट्री को फाइल नहीं मिल रही, फाइल नहीं ट्रेस हो रही.
Hmm.
हाफ द मैटर्स आर पेंडिंग, अ लॉट ऑफ मैटर्स, नॉट हाफ, a lot of matters are pending in courts because the files are not traceable anymore. That should not happen.
Hmm.
So
Hmm.
technology has to be used in order to do every step till it reaches for final hearing. If we address these processes, for instance, issuance of notice to a party, whether the notice is complete or not, whether pleadings are completed or not, these matters should not be listed in the court at all. These should be listed before administrative or registrars, who I think it happens in Delhi, I'm not sure, but in Lucknow also there are certain applications that are listed before registrar for Wakalatnama and all. But my suggestion would be that all
Yes, this all of this that you're referring to in Delhi
हाँ,
is
so
registrar.
not everything is here. For instance, sometimes matters are listed and the judge see whether the notice is complete or not.
Hmm.
Then he sees that the service report is bad, or the registry has stated that the notice is not complete, insufficient. All these matters should be heard in, at least in UP I'm talking about, in Lucknow. They should be heard by the registrar, or in fact, it can be seen by officials in registry that only when the matter is complete, the pleadings are complete, unless there is some urgent application which is being mentioned before the court,
Hmm.
they should be listed only when everything is complete. And once everything is complete, it should be sent into a docket, and the technology should directly list the matter. Okay, you are, this is the date you will get, this is for your hearing, and you have to be appear. And then the court should have the leeway कि अगर ठीक है आज मैंने 1 घंटा सुन लिया, मैं कल सुन लूंगा, मैं परसों सुन लूंगा. वो
Hmm.
फिर 3 दिन लगा सकते हैं, 4 दिन लगा सकते हैं. That they can see. But technology has to be used to streamline the entire process that leads to hearing of the cases. But I agree with Nikhil, you cannot have AI or anything that replace the either the legal mind or the judicial predisposition that you need for deciding these cases.
Right.
And also one more thing, I was just reading this is a little off the track, but I was reading the heading
Hmm.
of your podcast. It says that the government or the judiciary,
Yeah.
if you go to the national data grid,
Hmm.
more than 60% of the cases are pending because the lawyers took adjournments.
Hmm.
They were not available. If you see delay reasons, around 14, 1 crore 41 lakh 63,018 something cases are pending because the councils were not available.
Right.
Around 62 lakhs are pending because they are awaiting documents. 30
Hmm.
lakhs
Hmm.
because parties are not interested. Some 21 lakhs are pending, or 2 lakhs are pending because there are frequent appeals or applications in the matter.
Hmm. Hmm.
Record unavailable, just as we discussed, around 1 lakh cases are pending because records are unavailable.
Yeah, I mean, this though we observed in this, High Court YouTube and all. Also, when I used to watch cases, and I think it was Gujarat High Court, and they're listening to the judges there, and they purposely, it seemed like they don't bring certain document or provide, and they keep asking for dates even when the judge is scolding them or something. So of course, everybody is part of the problem, not
Exactly. So
just
the
the.
bar will have to take a call. The bar will have to take a call. It will cannot be the judges and the government. The bar will have to take a call. And the government के लिए one of the things that I believe the Supreme Court should do right now, take a suo motu cognizance and make sure that the limitation
Hmm.
that आपके पास 1 महीने का टाइम है या 6 महीने का टाइम है या 3 महीने का टाइम है, जो भी एक्ट प्रोवाइड करता है,
Hmm.
अगर गवर्नमेंट उसके 1 दिन बाद भी अपील फाइल कर रही है, इट शुड बी ऑटोमेटिकली रिजेक्टेड. इट शुड नॉट इवन बी अलाउड टू बी फाइल्ड. अभी क्या होता है, 2022 के एएफटी आर्म फोर्सेस ट्राइब्यूनल के
Yeah.
ऑर्डर्स को हाई कोर्ट में द अपील्स आर बीइंग फाइल्ड नाउ अगेंस्ट 2022 ऑर्डर फॉर अ डिसेबिलिटी पेंशन फॉर अ जवान हु रिटायर्ड इन 1980s.
Hmm.
उसके खिलाफ अब जाके डिफेंस मिनिस्ट्री जो है अपील फाइल कर रही है, अभी तक की नहीं है. वो एएफटी को इन्फॉर्म कर रहे हैं कि हम एग्जीक्यूट नहीं करेंगे आपका ऑर्डर, क्योंकि हम हाई कोर्ट में अपील दाखिल कर सॉरी चैलेंज रिट दाखिल करने जा रहे हैं 2025 में.
Yeah, yeah.
So I think there should be a suo moto cognizance on this, or that's the power they should use. If the government is not doing it, you do it. You say that even if a appeal by a government is a day late, it
Hmm.
will not be admitted. You fix your internal responsibility. You want to recover the money of that appeal money from the junior officers and do everything, but you do it. एटलीस्ट अपील तो टाइम पे फाइल हो. अगर करना है आपको लड़ना है तो लड़के खत्म करो ना. व्हाई आर यू ड्रैगिंग इट फॉर इयर्स एंड इयर्स?
Yeah, I mean, this is the major issue, no? This is not one
Yeah.
example, and this is these kind of examples. I mean, we all look around us, and we will definitely find one or
I am very pessimist. Nikhil is little hopeful, but I am very pessimist with the way things are happening, at least in the
yeah.
legal side of
But
the
like
government.
on the government part, they did take some steps, right, to make things easier, like the repealing of, say, the obsolete laws about 2000, right?
Yes. I went through the list of, I think, 1920 laws were there. Apart from one, I had not seen any one of them being applied till date.
There's no point deleting laws that aren't being
Exactly.
used.
ठीक है.
Okay. So,
I
So
mean, they were obsolete by
I'll give you an
themselves. They were obsolete by market practice यार.
I'll,
उसको delete करके क्या तीर मार लिया
I'll
आपने?
give you an example what they deleted and claimed that
huh.
it was an obsolete law. There was an Arbitration Act 1940. It was replaced in 1996 by
Hmm.
a new act. ठीक है. There was some act in 1976 that had amended the
Hmm.
1940 act. ठीक है. So they repealed the 1970 wala act, saying that it had become obsolete because 1940 act doesn't exist.
Arey.
अरे it's not being used यार. We are ठीक है. And that clause, that amendment itself had been nullified by a Supreme Court judgment in 1986, and after that another amendment had come and everything. मतलब it was crazy. That law had not even seen. मतलब they had replaced the
Hmm.
amending acts. They are removing the acts which are not even the substantive acts. So that was मतलब that was. I don't think that would have any effect on the judicial pendency or making life
Hmm.
easier for litigants. And the government is a terrible loser. There is no doubt about it. Nikhil mentioned the Ambani's
Hmm.
case, that how Devai Chandrachud granted the relief in
Yeah.
the curative petition. There is a better example of how government is a sole loser. Is they lost an international arbitration against Devas.
Oh my God, this is such a bad.
They
This is so
amended
scary to
the
listen to
act.
even.
They amended the act, arbitration act, to defeat that award, knowing that they cannot win. So they amended the act. They made the courts obligated to look into certain things that the courts were not obligated to look, and granted power to the court to stay the implementation of the award because they lost that international arbitration. And it's a very funny story. They lost that arbitration only because of one word: public interest.
Okay. So, I mean,
But in the press release, while cancelling the contract, one bureaucrat decided that I will write that the contract is being cancelled in public interest. The international court decided that since you have cancelled it not because of fraud but because of public interest, you are liable to pay them compensation. That's it. The entire case was based on this one single word.
funny, and another problem that everybody, I mean, we all know about it and faces, is that sometimes the certain bureaucrat or, say, government authority responsible and can take action does not take action, and ask the, usually ask the aggrieved party to go to courts, and only after court gives a judgment they'll act on it. Despite knowing it's a simple case, what can be done, they actually direct, and they don't want to, say, be in trouble or in danger or whatever. So, what is, I mean, then the case gets dragged for years and again burden the court. So, why can't we have a solution for simple things like this, where the actions are obvious?
What is the solution as per you to this?
No, no. I think what she is implying is when they are obvious, you should be able to bypass or have simpler
Yeah.
rules of evidence. I think
But we do have summary.
the thing, Diksha, is that when you as a layman
Hmm.
call something as obvious, to us lawyers, that's the starting point of creating complexity. Please understand
Yeah.
our life and the way we think. So much of this evidentiary law is about undoing what is
Hmm.
visible, right? And so it is about how do you prove that a certain thing has happened, has not happened, how do you take someone's word for it. The counter arguments are also solid, because if you don't go through these evidentiary stages, and evidence is not properly adduced, then mere allegations replace actual fact, and then you can have genuine cases of
Yeah.
injustice, right? So
Hmm.
where I am on board with you is, let's say, a lot of cases nowadays have clean
Yes.
video evidence, right?
Yeah.
Because there is just
Yeah.
so much CCTV, so on and so forth, right? I think step one should be
Hmm.
validate the CCTV footage. And once you validated the CCTV footage, there is very little else left. There's very little. So let's take the most recent example.
Hmm. Hmm.
That kid in Vadodara, right, who came out of his car and is
Yeah.
shouting another round, another round. What's
Yeah.
his
I mean,
defense? I'll tell you as a lawyer what I would raise as his defense. Even that video doesn't show him driving. It only shows him sitting there. It doesn't show him driving at the
what I
point of
mean,
impact, right? And it's an asinine defense, but it is a valid defense, right? But I would look at those kinds of cases and say,
yeah, and
this is
it was
clearly
not.
visible. The only evidence I'm going to rely on video evidence. Please secure the video evidence and have it tested for authenticity, and that's it. I'm relying
Yeah,
on
and
nothing
that was
else.
not just one case, right? It happened in Pune. I mean, it was back to back, two, three cases.
Many cases, and look, there will be no dearth of this because so many of our cities now have
Yeah.
CCTV
Yeah.
everywhere, right? Private organizations of CCTV, government CCTV exists. It's a lot of video evidence that can take care of
Hmm.
liability issues. That is examples of cases where the video evidence is crystal clear. Of course, in cases where sometimes people share it saying, look, it is this person. I look at that video and I can't see a face. To be
Hmm.
perfectly
Hmm.
honest with you, so in those cases
Yeah.
you won't be able to do it. But yeah, we can always have a faster route that way.
Yeah. But yeah, I mean, it's great that I had two of you because my plan was to understand कि क्या हो रहा है इतने pendency of cases में, why government is actually burdening the court so much, and being a major litigant in say 50% of cases, that means crores of cases, government is only the litigant. So, but what I understood from our conversation is that what's happening is in Delhi is not necessarily happening everywhere else, right? So a lot, so that uniformity that Abhishek said is needed, put things in place. And secondly, of course, I knew that we cannot have a, you know, things fast track or solution until unless we fill this problem of scale that we are facing. So that's another one. So yeah, so before we end this episode, any final comments that you would like to make, Abhishek?
Nothing, we are hopeful. I'm hopeful that there will be some urgency shown, some things will happen,
Hmm.
but I don't think the next few months are going to be great for judiciary. I think the government is going to launch an onslaught. We
Hmm.
are going to see either some kind of compromise in terms of the quality of judges or the ideology of judges being appointed, or we will see NJAC coming in, मतलब NJAC being tried again.
Hmm.
So something is going to happen. So it's going to be a tumultuous time for judiciary. And apart from that, Jai Samvidhan.
Yeah, Nikhil?
I mean, I think these issues that we're discussing, nothing that either Abhishek and I have said today is lost
Yeah.
within the system. I mean, everything is known. Like I said, to me, the main problem in India, whatever be the system we're talking about, whatever be the branch we're talking
Hmm.
about, is sort of feudal turf control. And NJAC is actually about feudal turf control. My fear with NJAC is we will end up replacing judicial feudal turf control with
Hmm.
political feudal turf control. So this is perhaps a cycle of development we simply have to go through. Maybe we have to go
Hmm.
through the slow development, slow churn for a while. But don't underestimate the things that are accretional. Now, maybe 5, 7, 8 years later, when
Hmm.
Abhishek and I, you have us back here, perhaps he'll be saying, okay, there is greater uptake on, say, video conferencing,
Yeah.
even in Mufassal courts in various parts of the country. Forget about other high courts, but even in the far off courts in various parts of the country. My experience is that certain high courts, he's absolutely right, certain high courts don't want it. Allahabad and Lucknow, Allahabad in
I
particular,
think
I was
even Bihar,
repeatedly told don't even try it.
the
Most judges
same
don't
case.
like it, right? But yeah, but when I
Hmm.
do it in Himachal, etc., there's no issue whatsoever. So this varies. These things will eventually become better. The point is a short one. That particular facility is here to stay. That's not
Hmm.
going away. There's no chance it's going away. How we get to a nudge
Right.
point of more and
Yeah.
more
Yeah.
adoption, we'll have to see. Other than that, we're not saying anything novel. We're not saying anything new. We're not saying anything
Hmm.
that isn't in some kind of report or otherwise known to people within the system. But implementation is a very difficult and complex thing in these
And
things.
irony of everything, the problem, the scale problem is that this vicious cycle when we say we have a lot of young population, working population, and we have access of everything, but we don't have the talent or what the problem or the intention to fill those vacancies in not just here, but judiciary, but other like police force and
Let me put it differently to that, Diksha. Let's say we don't necessarily rate at highest some of the human capital that will be coming forward to become judges. So what? That is the nature of you today. You have to accept that in a
hmm,
country, the justice that you get will be dependent on the people of that country.
yeah, yeah,
And if this is where we are today, then this is where we are today.
hmm,
Okay, that doesn't mean that you just sit back and wait for the great grand Superman to arrive,
yeah,
right? You have to still move forward with that volume, with that capacity, and even if it's a bad time for a while, we will learn over time and it will get better over time. But at least you start fixing capacity
hmm,
issues, right? You start putting them in place. So there's no reason waiting for the ideal candidate. The ideal candidate does not exist. The numbers requirement is
yeah,
immense. I think even the estimates that we're placing today are too low. They have to be much higher than that. There is no other way to do this. You have to go forward. And 10 years later, the quality will be better. I promise you this. In the 90s, what I saw of the Delhi
hmm,
High Court, 90s when I was a student, maybe early 2000s when I was a law
hmm,
student, it was, it did not compare with what I saw through the 2010s and now in the 2020s. Much better court.
yeah, yeah. Yeah, I mean, there's some optimism there. It will get better.
No, but it only gets better if you keep doing it. You have to
Yeah.
keep doing it, right? Like you cannot wait for it to get better. You have to keep doing it, and with seasons of experience,
Hmm.
everybody sort of also sees first and foremost this is a viable profession. It is a viable place to go into
Hmm.
in terms of being a judge from a young age, because you are forsaking certain income generation
Yeah.
opportunities. The power is better. There is a certain contribution to society. Those things, right? And
Hmm.
perhaps from there, if you've done that volume analysis, and you, even if you feel the quality of judgments isn't greatest, doesn't matter. Go through it. 10 years later, it will be better.
Yeah. Yeah. Yeah.
No point waiting for 10 years to start. I mean, you may not have changed your education system enough for it to be better 10 years later.
Very true. All right. I'll get back to you both again when we have a similar case. It was really nice talking to you and actually having two point of views and having a different, situation. Otherwise, I think with one we would have got one perspective, but I know things are not similar now, say in Delhi with respect to in UP and things like that. Thank you so much, Abhishek, and thank you so much, Nikhil, for joining us and for this wonderful conversation.
Thank you, Diksha. Thank you so much.
Pleasure to be here.
Thank you, listeners, for tuning in. If you're listening to this episode on Spotify, do follow and rate the show. I'm your host, Diksha, signing off. Jai Hind, Jai Bharat.